Hello, my name is Duncan Wilson from the Scottish Human Rights Commission, and I'd like to take a couple of minutes today to explain to you what the Commission's interest in historic abuse is and the process of interaction that we're proposing to advance justice for historic child abuse. Since the Commission was established in 2008, we have a mandate to promote and protect all human rights in Scotland, and we're what's called a national human rights institution. That means we're completely independent of government and of Parliament, although we account to the Scottish Parliament for how we spend public money. We have a status within the United Nations as a recognised independent human rights body. And when we became operational, we recognised, amongst other things, that there was an opportunity with the proposals that the Scottish Government was putting forward on, at that time, truth and reconciliation, and laterally acknowledgement and accountability for historic child abuse, to promote a human rights based approach to remedies and justice for survivors of historic abuse. So in 2010 we published this document here, which is a framework for human rights approach to remedies and justice for historic child abuse. That framework recommends a number of things to ensure that the human rights of everyone, including survivors of historic abuse, as well as current and former staff members in institution, are fully taken into account in any process of justice and remedies. There are really 5 elements to that framework. The first of those is participation. Everyone whose rights are affected has the right to take part in decisions which will affect them. That means they should have the information that they need, the support that they need, and really the conditions that would enable them to meaningfully take part in those decisions. The second aspect, and one of the biggest, is accountability. And we were encouraged initially when the government was consulting on acknowledgement and accountability. And in our framework we spelt out the elements which a human rights approach would require for accountability, and that includes really 2 general areas. The first is investigations and access to justice, and the second is reparations. In terms of investigations, a human rights approach really requires primarily a mechanism which would allow lessons to be learned, so that we can identify where we went wrong, how historic abuse was allowed to take place, and what we can do to make sure it doesn't happen again. So it's a constructive process, really, looking at state responsibility and where the state failed to protect children that it should have known were at risk of harm. In access to justice, we're looking at whether there are barriers which can be addressed which block survivors in properly accessing justice. So, for example, the prescription and limitation, or so-called time bar, the government is planning a consultation on that, and we'd like to see whether there are opportunities within that to look at different ways of addressing that issue to provide greater access to justice. Now, that doesn't necessarily mean that everyone who gets into, if you like, the civil justice system would be successful. Of course, far from it. They're very difficult evidentiary barriers, but at present the technical barrier of time bar is not really allowing people, if you like, their day in court. The second general area of reparations includes a number of things. The first of those is satisfaction, which might sound a strange word to use in this context, but it really means, amongst other things perhaps, being taken seriously, the recognition that that everyone who is recounting their experience should be treated with credibility and dignity. And the kinds of mechanisms that might secure satisfaction would be a confidential committee, and the government's committed to exploring a national confidential forum, and I believe is about to launch a consultation on that. But it would also include an effective apology. And we've been looking at the experience elsewhere in the world, for example in Canada and Australia, where laws have been passed, so-called apology laws, which remove fear of an apology being used as a basis for civil litigation or for voiding insurance contracts, which we understand have been among the concerns that institutions have had here in Scotland too. Other aspects of reparation include restitution and rehabilitation, to the extent possible, restoring to people things that they lost as a result of the harm that was done to them, educational opportunities, parenting skills, etc. And rehabilitation, which could include the kind of counselling and mental health and other health services that people will continue to require. Adequate compensation is an element of reparation. And in other contexts, certainly international practice recommends that there should be consideration of establishing a reparation fund where everyone who has responsibilities can be encouraged to make contributions to that are proportionate to the harm. And finally, guarantees of non-repetition, and that really is linked very much to the investigations element that I mentioned before. Without a mechanism which is sufficient to identify not just what happened, but why it happened, we won't be able to ensure effectively that we've done everything we can to avoid it happening in the future. The third element of the human rights framework is non-discrimination, effectively that no arbitrary barriers or distinctions should be made between people in having access to remedies. Empowerment is a positive obligation on the state really to do everything that it can to enable and empower people to take part in remedies, to take part in decisions as well. And that might mean things like ensuring that their physical and emotional security is ensured. Legality is the final and fifth and final element of the human rights framework, and that of course requires that all of the rights of everyone involved should be upheld in this process, whether that is positive duty to protect the right to life from risk of suicide, or the right to a fair hearing for anyone who might be named, or indeed the right to reputation, to private and family life, and a number of other rights. So that in broad terms is what we recommended in the human rights framework. That was published in 2010, and immediately following that the government initiated a pilot confidential forum, Time to Be Heard. At the end of the Time to Be Heard forum, the government committed to two things. The first was to roll out a national confidential forum, and the second, in December last year, we secured the ministerial commitment to engage with an interaction to pursue the possibilities for advancing the other recommendations which we made in our human rights framework. So that's really what we're here to hear your views on today. What we propose to do is an interaction is really an opportunity for everyone involved to get around the table and understand four things. The facts, and that really means what is it that people need and want to see to satisfy their sense of justice. What are the barriers that institutions and government and others feel are present which inhibit them ensuring those remedies, and what are the perspectives of others who are around the table. What is the analysis of the rights at stake, and to a great extent we can contribute that based on the work we've done in the human rights framework. identifying responsibilities, who has responsibilities in this area and how can they be advanced, and then as part of that negotiation then a recall to see whether the steps that were agreed have been implemented in practice. So an interaction sees all of those with an interest represented in some way around the table in an independently facilitated negotiation. The hope or the aim of that interaction would be to develop an action plan, a roadmap really, to take forward recommendations and ensure that all of the elements of justice are advanced, and where there are barriers, those can be addressed over time. And then of course the interaction would recall to review progress. It's not in itself a remedy, it's a process of negotiation to agree what can we do to advance the principle of justice, recognising the pragmatic limitations, financial constraints, concerns in reputation, other real concerns that institutions, government, local authorities and others might have. So we want to understand all of that and see how far forward we can move, where we can make progress, and indeed where there's still a need for outstanding issues to be addressed over time. It will be a constructive process. It will not be an adversarial process. The way in which the interaction runs with an independent chair, supported by the Human Rights Commission, an independent body, is designed to ensure that the process itself contributes in a constructive way that benefits everyone involved. So at the end of the day, justice can be advanced in a way that enhances the standards of childcare in Scotland and rights wrongs that were done in the past. I do hope that you're able to consider contributing to this process, and I hope that your discussions with the Centre for Excellence in Looked After Children, who are supporting us in preparing the interactions, are constructive. And if you have any outstanding questions or concerns, please do not hesitate to raise those with our CELSIUS representatives, and if need be with us as well. Thank you very much.